to destroy someone's life, it's not okay.
How did you investigate this matter?
I interviewed every one of these women.
And how do you think that you should have received this information to make it not lewd, in your opinion? You gave the opinion today that numerous items you identified were lewd in your eyes. How is someone supposed to communicate what someone else told them?
Well,
You're the HR director, so that's all I'm asking.
no, but it's fine to, I think we definitely want people to report information, but not when it's lies and untruthful.
He doesn't know it's
And
lies.
making false allegations. These people didn't tell him that. They told me they didn't tell him that. I interviewed them. They told me they did not tell him this stuff.
Well, do people sometimes lie to keep their job? Does that ever happen?
Do people sometimes
Do
lie?
people sometimes lie to keep their job? That's what I asked you.
These people don't work for
I
us.
asked you a question.
I'm sure they do, but these
Okay.
people no longer are employed for us. They have no reason to lie.
Do people
As a matter of
sometimes
fact-
lie? Oh, I'm sorry.
As a matter of fact, some of these women were fired and terminated and may have been disgruntled themselves, yet still didn't want to perjure themselves and make these false allegations.
Or maybe they just didn't want to be involved, and so they said, no, it didn't happen. Is that also a possibility?
That's a possibility, but that's a lot of people that would be lying,
Well,
as opposed to just one, Mr. Bloodsworth,
if he was
lying.
told, well, or others that are in the courtroom as well, right?
I'm willing to take a polygraph test.
Okay, well, if he was told these things and he wrote them down and communicated those to you as the HR director,
But if he
how is
wasn't-
that lewd?
But if he wasn't told those things.
What if he was?
And he's making sexual false allegations,
I-
and I determined through my investigation that he was not told this information, because I can only go by what these women told me when I investigated and interviewed them. They all deny these allegations, some in writing, and
You provided that to the prosecution?
I did. And, they all deny this. The only person that they have any allegations against are Mr. Bloodsworth.
Okay. If someone told him something and he has to report it to you, how can he do so using their words that they gave him without it being lewd, but still remaining truthful? Is there a way?
If he was truthful, there wouldn't be a
No.
way, but he was being untruthful according to the investigation that I conducted.
After the fact.
And the information that I have documented and submitted to the court, which you should have, of these women denying these allegations and saying they did not tell him this.
Again, the bottom line is, the information that was provided to you was so that you would have it as an HR director,
And then
correct?
I investigated it.
Yes, absolutely,
And
great.
it turned out that he was making false and lewd allegations via email with the intent to harm, which is the very definition of obscene electronic communication.
What's the
He did
intent
the
to harm?
crime.
What's the intent to harm?
He attempted to harm our marriage, he attempted to harm our business, our livelihood, he wanted to ruin our lives, and he's been trying to do that for years, which is why I just broke down crying. We've been through hell with this man, all we want is peace. We have presented him multiple times, just.
I'm gonna object to any
Please, please,
presenting of anything multiple times. How is it that reporting an HR issue to HR is ruining your life?
because it's false allegations.
Okay,
And
I understand that is your claim. His claim is that he was told this information. So to him, he received information from somebody and he
But
provides it
his
to
claim
you.
is not true according to the witnesses.
Again, I'm gonna object to anything anybody told her that's hearsay testimony. We can bring everybody in at another time and deal with that. But as we sit here today, I'm just communicating, how else is he supposed to communicate it to the HR department?
If it were true, this would
No,
be
ma'am.
fine.
Ma'am,
But when he's
Are you-
making up lies,
are you telling
false
me
and
that-
lewd allegations, which is what my investigation that I thoroughly conducted uncovered,
mhm.
then that's when it becomes a problem.
So anybody that makes an allegation that ends up later on by HR to be determined as unfounded or untrue, that person is making obscene
Well,
communications?
well,
That's
when
what I'm
they're,
asking you.
when they're sent electronically and it's involving all these false sexual allegations with intent to harm, then yes, that is a crime, and it has been committed here.
Okay. So
We
any,
have no motive for
so
writing
you
that,
can't file
other than
an
he
HR
terrorized us and he committed this crime. He committed this, he did this.
So anybody that files an HR claim that's unfounded violated the statute, is that right? If it involved sexual acts
I can't
and was
speak.
sent electronically.
I can't
That's what you
speak.
just said.
I'm referring to this case,
Yes.
not what anybody could ever do.
So
in this
unless
process.
it's 100% true, you don't wanna know what someone else said, you don't wanna know any allegations that were overheard.
I don't
You don't
want,
wanna know anybody else's opinion, is that right?
I don't want false allegations that are lewd, that were made up with the intent to harm, to be sent electronically. That's what I don't want.
Obviously, you read the statute numerous times because you keep quoting it, right?
And that's what happened here.
Okay.
He
But
violated
you're quoting the
and
statute.
that's our only motive. We don't wanna be here. We have businesses to run. We have a family to take care of. We wanna be giving back to our community and doing positive things, which we've prayed Mr. Bloodsworth would do himself. That he wakes up every day and his parents spends time.
Well, he wakes up, he woke up 3 days and sent you 3 emails, correct?
Well, I'm sorry, we can't talk about the
Wait,
social media.
ma'am, he sent you 3 emails, that's
I'm
what you're.
referring to the social
Ma'am, are we
media.
here for 3 emails that took place prior to November 12th of 2020, correct?
If that's the only evidence we're allowed to submit, then I suppose that's all we're gonna have to get to talk about today. And not all the other ongoing harassment and obscene communications that's happened since then,
Since
even though it's directly related to this case.
Since November 12th of 2020.
Right.
So it's your communications here today that things that took place after November 12th of 2020 should be considered by the judge as to whether or not he was guilty on or before November 12th of
I
2020?
think it goes to show his motive and his character, for sure.
I'm asking you a direct question. The items that took place after the affidavit was signed by your husband, you're saying should be considered as to whether or not he violated the law on or before November 12th, 2020?
Well, especially since
Your
it was
Honor,
a court order that was
that
violated
issue was
directly
already-
related to this case.
She's bringing it up.
But that matter is already handled before the court.
I
The court
didn't- I
says it's
wasn't
not
there.
coming in.
Absolutely, I'm not asking the evidence to come in, but
It's
Your
not
Honor,
argumentative, and I think the judge has already made a rule of that. We're not attempting to enter in anything involving those issues after the fact.
and Your Honor, if I may, we have a witness that has regurgitated the statute at least 40 times as we sit here today, without any facts that go along with the just blind communications that are just the statute regurgitated, the actual statutory language. She's willing to say anything she can say to get a conviction in this case. And I'm really trying to ascertain how in her mind, since she's communicating all these things that are lewd and problematic, how in her mind anything after the date of an affidavit would be considered relevant. And she refuses to answer the question.
That's not true. I like the answer question.
We're not gonna consider anything after November the, 12th, I think it is, November 12th, 2020.
I think
The city has made no effort to draw that testimony. I think if the defense counsel does, I think
I
it's
would draw-
opening the door to those other issues.
I'm not asking the question, she brought it up.
Well,
I would draw the question
okay.
to your witness.
Redirect,
Okay. Yeah, no redirect. No redirect, Judge.
arrest,
City arrest, Your Honor, that's correct.
you can step down, Ms. Melissa.
Your
Thank you.
Judge, you have your. I was just making sure you had your exhibits. I was just making sure you had your exhibits. They
I
weren't.
have three.
Yes, Your Honor.
We make a motion for a directed verdict, Your Honor. The evidence that's been submitted to Your Honor is related to emails that are in no way, shape, or form in violation of the statute. It's the only way an individual has to communicate to human resources that an issue has been brought to their attention. And just because it's an uncomfortable situation, just because it's uncomfortable information, that adultery and sexual harassment, while those are definitely uncomfortable subject matter, he's not making lewd or lascivious comments about anybody that's testified here today. He's not making comments about them like, I want to do something. This statute is intended, and obviously intended, for individuals who contact people and making statements or comments related to someone's body or related to what they want to do, things of this nature. The subject matter of these text messages is information he received from another source, and he's merely communicating it to the HR department. Now, it just so happens that the HR department head is the wife of the individual who's the subject matter of the information. But what is someone supposed to do? If they have information that they need to share with a company, this is how you do it. And in no way, shape, or form is it lewd or obscene to communicate merely what someone told you or what you observed in your communications or interactions. There's been nothing other than these emails. So the emails stand alone and on their face to show that he merely was providing information. The information was utilized appropriately by Dr. Sombrero. She conducted an investigation and found no wrongdoing, no harm, no foul. But unfortunately, charges were filed before she even got the information whether or not anything happened. That's irrelevant. The statute was not violated. And we make a motion for a directed verdict that evidence does not support beyond reasonable doubt the violation of the statute.
And in response, Your Honor, I think there's at least a scintilla of evidence for the court to consider regarding the allegations. Outside of phone calls, we have at least 3 emails the court has to review on or about the 12th of November of 2020. And the circumstantial evidence would also show these emails are in fact from Mr. Brian Bloodsworth. That's stipulated too. These emails are of course using language. They're very explicit. These would be considered or defined lewd, lascivious, and obscene. These women that they're involved with no longer work for the company. Mr. Bloodsworth no longer work for the company. These issues are old and stale. There's no obligation for Mr. Bloodsworth to present these findings to anyone. In fact, when they were presented, the tone of the language that he uses is, "Oh, I heard that you're HR." Mr. Bloodsworth knew that. He knew that when he worked for them. He knew this was a husband and wife, people where he knew this was all being directed to Mr. Mercer's wife, and that she would be getting it. And I think all of that would go to his intention to annoy, to harass, and also it includes obscene, lewd, lascivious type conduct on someone to upset a wife. If he worked for them as a manager, he could also know he could have taken a legitimate issue, if it was, to a corporate level if he was very much concerned with that. Instead, he doesn't do that. He goes to a local manager over a year later involving issues with people who are no longer employees and sending this to Mr. Mercer's wife, who's also an employee of Taco Sombrero. We do believe there's at least a scintilla of evidence for the court to consider. And we'd ask the court to deny counsel's motion.
Yeah. Hey, Judge, he made just one quick mistake. He actually did send an additional email to the corporate office. And I think Mr. Anker was just a little bit confused. So he did go that extra step.
Part of the signature.
I think so.
Correct.
I think so, that's right.
All right, I'm looking at the statute 97, 29, and 45. They're talking about any type of electronic communication, whether it's by telephone, emails, my space, your space, or whatever all these things are. Twitter, I guess, would have been included in there. I'm not on any of those things,
Me neither.
so I don't know all the names. It says, which is obscene, lewd, lascivious with intent to abuse, threaten, or harass any party to a telephone conversation, telecommunication, or electronic communication. The telephone calls that Mr. Mercer was referring to indicated, for what the testimony was, he was in the Key West area when he got those. There was no testimony as to where the calls were originating from. They could have been from Mobile, Alabama, or someplace else in Florida. So I'm not considering the 14 or 15 calls that were made in a 10-minute period. I'm not saying he didn't do it. I'm just saying you weren't able to show it. And it's just a technicality. And it's great when it's a technicality that helps you. And it's how stupid can the judge be and how stupid can the law be when the technicality works against you on it. On paragraph D of that section, to make a telecommunication or electronic communication with intent to terrify, intimidate, or harass, possibly harass would be the portion of that. But the last part of that paragraph is, and threaten to inflict injury or physical harm to any person or to his property. That portion wasn't shown. Paragraph C, make a telephone call. That's not applicable. Even though he didn't, Mr. Mercer says he didn't state his name or anything, he just recognized the line. So that's not going to be applicable. Paragraph D, to repeatedly call with intent to harass at the call number. Once again, that's the Key West portions. Paragraph B is the same. In paragraph 7, for purposes of this section, telecommunication, electronic communication means to include any type of telephonic, electronic, radio communications, transmissions of sound, signals, data writings, imaging, text, voice, video, etc., including the internet. There wasn't any testimony about any type of things being placed on the internet. I'm not happy with the way I'm having to rule. I'm gonna grant the directed verdict. My understanding is there's been some additional charges filed for violation of the protective order. Just so council will know, I did sign off on this billboard.
Okay.
I'm gonna set the bill at $500.
Okay. You just need to go right now to the.
They also take it when we leave here, they'll process the paperwork.
Okay.
Mr. Bloodsworth,
No.
you got a good attorney, you better listen to him. And realistically, right now, I'd like to put you in jail. I'm gonna recuse myself from hearing this particular case. I'm gonna let Judge Steele deal with it. Realistically, I don't think I could be fair to you, having signed off on this, but I've signed off on it. Realistically, you better not contact them. The only people you better be calling is your attorney and whatever relatives you have. But don't be contacting these people or their employees in any way, shape, form, or fashion. Any questions?
Nothing from the city judge. May I consult Mr. Your Honor, the court required of contact was through the disposition of this last case.
You're gonna take it?
Now that he's
Oh, no, not yours.
okay.
This is all.
Would the court regarding the new cases be able to put that in
Post
writing?
freaking bond again, it's $500 bond, you can do a cash bond or get a bail bond, and then you got the charges for the contempt that they filed today, you understand? And that's the contempt of the order that I went over with you earlier, and no contact of them or their employees, you got me? Okay, just wanna make sure you understand. What you won here today, case is dismissed, you were acquitted, okay?